spaces. It's not intended to create a two-family structure or a duplex. The size of the accessory dwelling unit is usually subsidiary to the main residence, and owner occupancy is typically, but not always required. And this is looking at what's going on throughout the country with accessory dwelling units. How people do it in Massachusetts, people in municipalities, differs. And we'll get into the construct of this bylaw. It's also called an accessory apartment, in-law apartments, family apartments. There's been lots of different titles and names, granny flats. It varies.
I've had several conversations with Mrs. Lucy regarding this. I think the way it's been worked up has been worked up very well. I do have some questions though, and one pertains to the enforcement issue, because certainly this is going to have an impact on what we consider to be a residential town, a single residential town for the most part. So I think that there are protections that need to be put in there that does just that, protects those people who already have an investment in their particular neighborhood. I mean, I want these units so that we know are out there. I want them recognized. I want the taxes paid on them. If there's new situations that arise, I want the same thing to happen. However, we do always have to remember that even though we have Chapter 40, etc., and the state has put many things in the local communities, and they have come through with very little to the communities that they have put these different obligations onto. I think it's in our best interest at the local level to protect ourselves here. So that if we're going to comply, and I think we do need to in this case here, but let's make it such that it's not necessarily something that happens, that's forgotten about, and piled away.
My concern is, is this almost exclusionary? There are so many illegal units in town. You might have requirements for 10,000 square feet. You might have requirements for no more than 3 people, only R1 and R2. I think it's excluding a lot of people that we need to come forward because of all the safety issues. And it's almost, I'd like to see the Board of Appeals not be mandated, but have some flexibility in making some exceptions for some things. Like if a unit was maybe 9,000, it was 9,000 square feet. Not so hard to get 10,000 square foot number. I don't really see a lot of problems where you say never any more than 3 people. Well, if you had a young couple and they have 2 small toddlers and there's 2 bedrooms in this unit of 900 square feet, I don't think I have a problem with that, and I don't think we should. But some of the language just seems somewhat fairly hard. I certainly don't think, one comment I just wanted to add was, I don't think that necessarily putting some ordinance like this into place is going to devalue, if it's handled properly, a single family neighborhood. I don't think that should happen.
And I'm the chairman of the zoning board. We did talk about this at length at Bob Cox, member of your committee, and is also on the Board of Appeals, and he would bring us monthly updates. And I think with the feedback from the board members about all the things that we have seen over the years, I believe that this proposal has included everything that we need. The only issues, again, about recording it, I was wondering if maybe as part of that recording, a copy could come to the Board of Appeals and to the building inspector to be made part of that file. Perhaps that's a better way to keep track of it as well, to have a separate filing for those.
Meeting member Precinct 10, 50 Bell Street. First, I want to thank Janet, you and your committee for all this hard work. I know how difficult it is to pull a process like this together. And what strikes me is what you've done, the process that you've used. You've looked at other communities. I seem to recall hearing you moved to Lexington in this process, and you've also had this peer review. And this is something that is was dreamt up within the context of Saugus. I know we had some proposals before town meeting that basically would have allowed anything anywhere with just some sort of a permit. This is well thought out, it's comprehensive. And
299 Walton Street. And I'm sure this probably been answered that I was thinking. If you have an in-law apartment, say you put an in-law apartment in your house, according to the laws, you let your family move in, your family's there for 5, 10, 15 years, they pass away. Now you get a big apartment in your house. What's to prevent you, or what's the enforcement on keeping that from you renting it out and just being as an income property as opposed to an in-law?
That's part of the certification process of occupancy. So that
Which
would
is
be
an
again
enforcement.
required under in administration and enforcement, the building inspector would be required under this, the way the draft is written, to enforce its occupants and recertify them. So therefore, if you were changing the use from being a family use, then that would be an issue, and it would have to be dismantled. That's the requirement under the bylaw.
Very likely.
Well,
I mean, legally, yes, but reality, probably